A 504 plan is simply a 504 is a non-discrimination statute. It basically just means that you are not going to treat this person with a disability differently than a person that's non-disabled. And we can have a separate segment on 504 plans and why they're not very useful, because there's really no ability to enforce them. But a 504 plan for an autistic kid is sort of a joke in my book. I mean, the writer mentions that she's in Maryland, so I'm answering this under California law, but California law, as far as the definition of autism, really parallels the federal statute, which would apply in Maryland. So she's got two assessments. I don't know who did them, what the qualifications of the people are, or what they say, but I'm assuming they say that as far as the student goes, he does have needs for special education and related services, even if he's functioning at grade level academically. So that's my assumption. Now, there's a case I wasn't able to run down, but I can if people want. It's from Baptiste. It's one of these cases where it was a high-functioning autism or Asperger's person who didn't have poor grades, and so the argument was that they don't need special education and related services to access the curriculum. So we want to look at the question of what that means, access the curriculum. Now, first of all, as far as autism goes, the federal definition, now I am going to read, so forgive me, but autism means a developmental disability significantly affecting verbal and nonverbal communication and social interactions, generally evident before age 3, and adversely affecting a child's educational performance. So obviously we meet the criteria for autism, and we have to show an adverse impact on educational performance. I'm going to come back to that. Other characteristics often associated with autism are engagement in repetitive activities and stereotype movements, resistance to environmental change or changing daily routines, and unusual responses to sensory experience. Now, I wanted to read this because the definition was just changed in 2014, and it really does parallel the federal statute. So you're looking for something that adversely affects educational performance. Educational performance is not defined as narrowly as the districts would like it to be. Districts are responsible for providing special education and related services if, absent those things, the person is not going to be able to transition to adulthood and vocational employment. So in other words, if you're getting A, B's, and C's and D's, but you have behaviors, or you're so shy that you don't know how to interact with your peers, or you're having executive functioning problems, such that whenever the time comes that you're going to need to do the job interview, and you're going to flunk the job interview, you're entitled to special education to remediate those particular difficulties. So I'm assuming that in addition to looking at academic learning in the classroom, the two assessments that the mother from Maryland has talk about these behavioral deficits, executive functioning deficits, and so on. And there should be goals written to address, attention, executive functioning, social behavior, withdrawal, etc. And because there are needs in those areas, and those things, when remediated, let you be more likely to be successful in vocational employment, you are entitled to have an IEP, even if your grades are, C grades. IDEA has a low standard in terms of what's acceptable. You just have to do a C grade or better. But that doesn't end the analysis. So what should the mother do? She's got two assessments. She doesn't want to spend any more money. How is she to attack the finding of ineligibility? Well, basically, she's entitled to an eligibility hearing at which her experts will testify as to why her son or daughter needs special education to address, executive functioning behavior, socialization, and so on. And that ought to take care of the matter. I have a hard time believing that a hearing officer is going to say a high-functioning autistic child who's, been evaluated for the ADOS or some other gold standard by a, doctoral level person is just not, going to have problems or need special education. It's not going to fly, so the district's basically bluffing you, and you've got to call them on it. And you need to get a lawyer to do that.